Welcome back to And Another Thing. I'm Larry Menti. We continue our conversation now on threat scores and the increasing use of technological surveillance by local police departments. To join us in the conversation right now is Professor Greg Bordelon, who is in the Legal Studies Department, and your specialty is constitutional law. So you know about the threat scores. You read the Washington Post piece. Do you have a problem with it?
Problem in the context of what I research, I think, is an interesting proposition. I think that if police forces continue to use it, this will trigger some civil rights and liberties litigation. As I understand it, as the research happens now, if the software is used in a way that doesn't individually violate someone's right of privacy, it may be permissible. But again, that's a shifting norm that the courts have to wrestle with.
Well, let's talk about the right of privacy. It sounds like one of the problems that civil rights advocates have and some privacy advocates have is the fact that they're cherry-picking social media sites and just certain words off of social media sites, and they may read those words inaccurately because they're counting on software. Is that a privacy concern?
So I think there are two issues with that. One is we start from the general proposition that what is on social media is public, and there would be an expectation of privacy that is very minimal in the context of what you post on social media sites. But I think the real question for civil rights groups is how do the police come to find that information? And again the argument that the software is permissible is that if the police are in a position to find something that any layperson could find, it's okay. If the police are engaged in activities that would allow them to seek something online or otherwise that they would not have a right of access to, that's what presents the issue.
Let's make that clear for people, so how they came upon that information. So if someone's driving to a house and they hear there's domestic violence and they ask for the threat score, you're saying that would be okay?
Right. And the courts usually context that in the words of reasonable expectation of privacy or in the open domain. So if a police officer is somewhere where it's in the open domain, whether it be, as you indicated in your example, driving, or online on a social media site, it would be fine.
But as they're doing in Portland right now, where the Portland police looked on Twitter for people living in the Portland area using the hashtag Black Lives Matter and made a list of those people, that's being investigated right now as police wrongdoing. They came about that information the wrong way, you would argue?
I would argue not in the direct context of the privacy issue, which happens under the Fourth Amendment. There probably would be concerns under the 14th Amendment under discrimination, meaning that if the police are targeting groups based on a prohibited or a protected class, that's a violation of another part of the Constitution. If they are, though, engaged in a process where they are reasonably allowed to access the information to the public, that may not be a violation of part of the Constitution, but that certainly doesn't mean it's not a violation of the parts that protect discrimination.
Okay, I'm going to leave this threat score in 1 second and talk about other technology, but just to clear up a couple of things with exactly what you're talking about. So the bottom line is, if I have a reason to find out your threat score, the reason is the most important thing.
The reason under the case law is the most important thing. So I think that of course, will not sort of dispose of the issue for the threat scores under the Beware software. I think what happens is if you engage in a dialogue where there is an impermissible reason, then police forces will have to be trained on how to properly investigate the reason that justifies the use of the Beware software.
And every time I have a compelling reason or a sufficient reason, I will be on steady legal ground.
Well, all of the time is an interesting proposition under the law, but most of the time, if the police can reasonably gather based on competent resources of the police that the reason that they're using the software is okay, then arguably a court will likely uphold the use of the software, presuming that the information in the software is all in the public domain.
And will the argument always work if it's to protect an officer's life, to make sure he knows what's on the other side of the door? So
most of the time, the Supreme Court said in Terry versus Ohio about 50 years ago that protecting the officer's safety under Terry versus Ohio and a reasonable suspicion to be able to protect that safety allows more discretion in the police. But again, the police has to be sure, and the reason that they're using the software is indeed that. It can't be a pretext for some other impermissible reason which may violate someone's privacy.
Now, this is just the latest thing. It's not the only thing.
Exactly.
Local police departments, it seems like everything starts in the federal government and it starts with the military. They get it first, and they don't have the same constitutional restrictions. And then they give it to local law enforcement, unless they're using it on American citizens. Then they give it to local law enforcement, and they have to decide whether they can use it or not. So let's talk about a couple specifics. There is a drone that can go up over a protest site. and sort of like a Hoover vacuum, just pick up all of the cell phone conversations. Is that constitutional? Because that's being used right now.
My students would love to hear this. Of course, it depends. It depends, again, on several things that particularly the Supreme Court has elucidated on whether or not it's permissible under the Fourth Amendment. If the police forces are reasonably in a position to be able to acquire the information that presumably violates someone's privacy, it is. But if, for example, a police force secretly acquired at a very expensive rate a piece of software that would normally not be in the minds of individuals, and an individual could say, hey, this violates my privacy. I thought only the military had this. Then a court would be more likely inclined to say, you're right, that's a violation of the Fourth Amendment.
Professor Greg Bordelon, Monmouth University. Another thing continues right after this.